Welcome to IP Concerns Deep Dive, the podcast version of our IP Concerns blog from Cascade Law Group. Here, we unpack intellectual property-related, real business and brand protection topics in a way that actually makes sense, no legal experience required.
Picture this. You're browsing through a local vintage shop, or maybe you're deep scrolling online, and you finally find it. An old, slightly battered, but undeniably authentic designer jacket.
Ah, the best feeling.
Right. You buy it, you take it home, but instead of just wearing it as is, you decide to get a little creative.
Okay.
You cut it up, you alter the shape, maybe you stitch it together with some other sustainable fabrics you just happen to have lying around, and you transform it into this completely new, beautiful, one-of-a-kind bag.
Sounds amazing, honestly.
Yeah. And so you list it for sale online. Your customers love it. It is environmentally sustainable. It's highly artistic, and it keeps textiles out of the landfill. You'd think everyone wins.
Yeah.
Like, what could possibly go wrong?
Yeah. If we actually look at the way the global legal system is currently shifting, pretty much absolutely everything could go wrong.
Yeah.
That beautifully crafted, sustainable bag might just be a one-way ticket to a massive lawsuit.
And that completely blew my mind, because we were looking through this really comprehensive legal briefing recently, and it's titled The Global Legal Landscape of Branded Upcycling.
Right.
And it turns out taking scissors to a designer item is, it's a fantastic way to get sued by a multi-billion-dollar conglomerate.
So, okay, let's unpack this, because upcycling is universally celebrated right now.
Oh, absolutely.
It's the darling of modern conscious culture. It's all about, saving the planet, reducing waste, breathing new life into old things. I am genuinely surprised that something so positive is landing independent creators in court against the biggest luxury giants in the world.
Yeah, I mean, it's a fundamental clash, really, a clash between changing societal values and very rigid legal structures.
Right.
My core thesis for you as we explore this landscape today is basically this. While upcycling is rightfully championed for its craftsmanship and its environmental benefits, courts worldwide are aggressively signaling that sustainability does not automatically excuse intellectual property violations.
The intention might be to save the planet, but the law operates on entirely different parameters.
It is wild to think about.
Yeah.
But before we look at the actual lawsuits and the sheer scale of the legal threats facing these creators, we first need to understand the mindset of the upcycler.
Sure.
Like, why did these independent designers think they were legally safe to begin with? I mean, nobody starts an Etsy shop or a small fashion label with the goal of getting crushed by a luxury brand's legal team. They must have thought they were following the rule.
Oh, they absolutely did. And to understand the trap they fell into, we have to look at the history of a specific legal doctrine. Upcyclers always try to hide behind this concept known as the first sale rule.
Okay, the first sale rule.
Yeah, it's a foundational pillar of commerce. The general philosophy behind it is just to prevent monopolies from controlling secondary markets.
So, to put it simply, if I buy a physical book, I read it, and then I want to sell it to a used bookstore down the street, the publisher of that book can't step in and say, no, you're not authorized to sell that.
Precisely. That's the underlying logic. Intellectual property laws dictate that once a brand lawfully sells a genuine product to a consumer, the brand's control over the distribution of that specific physical item just ends.
You own it.
Exactly, you own it. If you buy a car, a book, a designer handbag, you are legally allowed to resell it. The first sale exhausts the brand's right to control what happens to that item out in the stream of commerce.
Which makes total sense, because otherwise we wouldn't have thrift stores, we wouldn't have used car dealerships or, garage sales.
Right, the whole secondary economy would collapse.
So upcyclers are operating under the assumption that, hey, I bought this authentic designer jacket legally. The first sale happened. It is my physical property now. I can do whatever I want with it and sell it.
That is the exact assumption. And here's the massive catch, and really the core tension driving all of this litigation.
Okay.
That first sale protection usually evaporates the moment a product has been fundamentally changed.
It just disappears.
Basically, yes. The doctrine was designed to protect the resale of the original item. Because upcycling, by its very definition, fundamentally alters the item, the original brand never actually agreed to the new, altered product being put into the market.
Oh, I see.
You are no longer selling the jacket they authorized. You're selling a totally new product that just happens to still carry their brand identity.
Okay, I think I have a way to visualize this. So it's like, I legally buy a famous artist's painting. Under the first sale rule, I am totally allowed to hang it in my house or eventually resell it to a gallery just as is.
Right.
But if I take that painting home, paint a giant neon mustache right in the middle of it, and then try to sell it with the original artist's signature still visible at the bottom.
They are going to come after you.
Yeah, that artist is going to sue me because I'm passing off my modified neon mustache version as if it were their authentic creative vision.
What's fascinating here is that your analogy perfectly captures the dual nature of the conflict. Yeah, this is essentially a philosophical battle over a brand's fundamental right to control its own image, its reputation, and what it puts out into the world, pitted directly against an independent creator's right to modify physical materials that they legally bought and paid for.
It's a huge collision of rights.
It is. When you alter the product but keep the brand's markers, you create a likelihood of consumer confusion. People might think the brand authorized that neon mustache or, in our case, that specific upcycled bag.
Okay, so now that we understand the legal loophole, this evaporation of the first sale rule through alteration, let's look at how this friction plays out in the real world when billions of dollars are at stake.
It gets messy.
Yeah, because based on the sources, it seems like the United States is currently operating as this chaotic Wild West of legal threats.
The U.S. landscape is incredibly volatile right now. There is a massive wave of trademark disputes happening, but very little actual legal clarity coming out of them.
Right.
The briefing highlights several high-profile clashes to illustrate the scale. For instance, Chanel sued a company called Shiver plus Duke.
Oh, I think I've seen them.
Yeah, this company was taking authentic Chanel buttons, just literally cutting the buttons off vintage garments and repurposing them into jewelry. Necklaces, earrings, things like that.
Which is incredibly popular. You see reworked designer jewelry everywhere on social media right now.
You do. But Chanel argued this was textbook trademark infringement. And then you have Levi's. They challenged the high-fashion brand Caperni over reworked jeans.
Oh, wow.
Yeah, and LVMH, the luxury conglomerate behind Louis Vuitton, has taken really aggressive action against products made from repurposed Louis Vuitton canvas. And the sources note that Nike and Ralph Lauren have also been heavily involved in deploying their legal teams over similar upcycling disputes.
Okay, I have to push back on this a little bit, specifically on the Levi's and Caperni situation.
Sure.
If Caperni is using authentic Levi's denim to make these cool reworked jeans, isn't that just a massive win-win for everyone involved? Well, Levi's gets free marketing showcasing how incredibly durable and timeless their denim is, and Caperni gets to be a sustainable, innovative brand. Why would a major corporation spend millions of dollars litigating this? Like, how does a beautiful, high-end, upcycled item actually hurt them?
Because the law doesn't care if the upcycle item is beautiful.
Right.
It cares about unauthorized control and a concept called trademark dilution. Brands don't view this as free PR. They view it as an existential threat to the legal monopoly they hold over their name.
An existential threat.
Yes, because in trademark law, you have an affirmative duty to police your mark. If you see someone using your brand name on a product you didn't authorize, and you let it slide because, it looks cool, you are setting a legal precedent that you don't control your trademark anymore.
So if they let the good upcyclers slide, they lose the legal power to stop the actual counterfeiters down the line.
Exactly. You risk losing the trademark entirely. Furthermore, even if Caperni-specific jeans are high quality, Levi's has zero quality control over that manufacturing process.
Oh, that makes sense.
Right. What if an independent upcycler uses cheap thread to stitch the bags together and the strap breaks after a week? The consumer sees the Levi's logo or the Chanel logo and subconsciously blames the brand for the shoddy workmanship, not the independent creator. That is dilution.
I see. It's the terror of taking the blame for someone else's mistakes, combined with the legal obligation to act like a bulldog or risk losing the rights to your own name.
You hit the nail on the head, and the really frustrating part about the U.S. landscape is how these disputes actually resolve. Almost all of these cases, Chanel, Levi's, LVMH, they largely settle out of court behind closed doors.
Meaning nobody actually wins or loses in front of a judge.
Exactly. And because they settle, they don't create clear, definitive legal precedents. We don't get a judge writing an opinion saying, here is the exact line you cannot cross.
That sounds incredibly stressful for small creators.
It is. However, the sheer volume of these lawsuits shows a very telling trend. Major brands view these upcycling practices as strictly infringing, and they are highly willing to deploy endless capital to aggressively protect their trademark rights, even without those set legal standards in place.
It's essentially regulation by threat of litigation.
Pretty much.
It's intimidation by budget. If you're an independent upcycler sewing bags in your studio, you cannot afford a 5-year legal battle against Chanel to prove your point about the circular economy. You just settle, you stop selling, and you shut down.
Right.
But while the U.S. operates in this murky gray zone of confidential settlements, our sources show that courts elsewhere in the world are forcing a definitive legal answer to this clash. And the hammer is dropping hard.
It really is. European courts, for example, have been far more direct, and they are systematically dismantling the defenses that upcyclers try to use.
Like,
Well, let's look at Switzerland. The highest court there recently dealt with a case involving customized Rolex watches. The court made a very specific mechanical distinction. They ruled that private customization of a Rolex is perfectly fine.
okay.
So if you buy a Rolex and you want to completely change the dial, add aftermarket diamonds to the bezel, and just wear it yourself, you can do that. But the moment you try to sell that customized Rolex to someone else, you have crossed the legal line into trademark infringement.
Because tying it back to what you said earlier about quality control, Rolex can't guarantee the waterproofing or the movement or the quality of those aftermarket diamonds once it leaves their factory.
Exactly.
But their famous crown logo is still sitting right there on the dial.
That is the core issue. But the legal philosophy gets even stricter and, frankly, more fascinating when we look at France. There is a very recent 2025 case highlighted in our sources involving Hermès.
Oh, the Birkin bag company.
Yes. But in this case, independent creators were taking authentic Hermès silk scarves, cutting them up, and turning them into jackets.
Which, purely from a design perspective, sounds gorgeous.
Oh.
I mean, I could see why people would want to buy that.
Oh, totally. The craftsmanship wasn't the issue for the French court, though. French law has a deep historical precedent of protecting what they call the moral rights of creators in luxury houses.
Moral rights.
Yeah. An Hermès scarf isn't just viewed as a piece of fabric, it's considered a protected work of art. The court ruled that cutting up those branded products and selling them as new items violates both trademark and copyright laws.
Both of them.
Yes. And crucially, the court explicitly rejected the defense that artistic freedom or environmental sustainability should outweigh the brand's intellectual property rights.
Wow. So they literally heard the creators say, we are participating in the circular economy, we are saving textiles from the landfill, this is transformative art. And the French legal system basically said, we do not care. The sanctity of the brand's property rights matters more.
They did. The court made a specific point to note that the original Hermès scarves were still valuable and resale ready. This wasn't a case of rescuing trash from a dumpster. This was taking a pristine luxury good and destroying its original form solely to profit off the brand's recognizable patterns.
Well, that distinction changes the narrative completely. It really pokes a hole in the whole we're just saving the environment argument if the original item was perfectly fine and functional.
Exactly.
It brings up this really deep philosophical question.
Yeah.
When we buy a luxury item, do we actually own it, or are we just licensing the right to wear it exactly as the brand intended?
It is a profound question about the nature of modern ownership. And, if you think Europe's stance is rigid, the courts in Asia are taking the hardest legal line of all.
Really? Harder than France?
Yes. In Singapore, courts have ruled that upcycled goods made from branded materials can actually be classified legally as counterfeit products.
Wait, stop right there, because that flips the entire definition of the word fake upside down.
It does.
Imagine taking a real, authentic designer bag that you paid thousands of dollars for. You cut it up, you turn it into a high-end wallet, and you were told by a judge that you were selling a counterfeit. We usually think of a counterfeit as a cheap knockoff made in a secret factory with fake leather.
Yeah.
But in this scenario, the materials are 100% real.
It sounds like a total paradox, I know. But if we dive into the mechanism of trademark law, it makes perfect sense from the court's perspective.
Okay, explain that to me.
A trademark is not a guarantee of the raw materials. It is a guarantee of the origin. The brand did not design that wallet. The brand did not stitch that wallet. Therefore, the final assembled product is a fake, even if the leather used to construct it was originally sourced from them. When a consumer buys that upcycled wallet, they are paying for the aura of the brand, an aura that the upcycler effectively hijacked.
So the authenticity of the material doesn't transfer to the new object.
Exactly. And the sources note that similar highly restrictive rulings have come out of China and South Korea as well. The Asian market is becoming a heavily fortified zone against unauthorized upcycling.
So if you're a sustainable fashion creator listening to this, you are probably sweating right now.
Probably.
With the U.S. regulating by lawsuit, France rejecting the sustainability defense entirely, and Asia labeling upcycled goods as literal counterfeits, what are the workarounds? Because whenever a legal wall goes up, people try to find a side door.
They do, and the sources actually document several quick fixes that creators have attempted over the years.
Let me guess, they didn't work.
Pretty much all of them have failed. For instance, keeping the brand's logo visible on the new item is almost guaranteed to cause trademark problems, as we saw with the Chanel buttons. But simply removing the logo doesn't always fix the issue either.
Why not? If the logo is gone, isn't the trademark gone?
Not if the pattern or the design is iconic enough.
Well, like the prints.
Right. Think about the Louis Vuitton monogram or a specific Hermes print. Removing the actual metal brand nameplate doesn't stop the fabric from being instantly recognizable to any consumer, which still triggers infringement.
Okay, what if I were an upcycler, and my first instinct was just to slap a massive tag on the reworked jacket that says, "Hey, I made this in my bedroom. Levi's had absolutely nothing to do with it. Please don't sue me." A giant disclaimer. Problem solved, right?
It seems logical, but courts have generally found that disclaimers rarely hold up as a strong defense.
Really? Even if it's super clear?
Yeah, for one, it doesn't magically erase the initial consumer confusion when they first see the item online. But more importantly, it doesn't stop what lawyers call post-sale confusion.
Post-sale. Meaning, what happens when the item is out in the wild?
Right. When someone is just walking down the street wearing your upcycled jacket, the people passing by them on the sidewalk aren't stopping to read the fine print on the inner tag.
That's true.
They just see the Levi's pocket stitching on a weirdly shaped jacket and form an opinion about the brand. Plus, as the Hermes case showed, copyright issues, which protect the actual artistic design or pattern of the fabric itself, separate from the brand name, are still totally unresolved globally.
So if keeping the logo is bad, removing the logo doesn't help, and disclaimers are legally useless, is the independent upcycling movement just legally doomed?
It raises a really important question about how entire industries evolve. I wouldn't say it's doomed, but it is going to have to fundamentally transform.
Okay.
Synthesizing all the sources, the final takeaway for both brands and creators is that the rogue, unauthorized era of upcycling is likely closing. As this practice scales up, brand owners realize they need clear, consistent enforcement strategies. For upcycling to survive both sustainably and legally, the future points almost certainly toward authorized upcycling.
Oh, authorized upcycling, meaning the brands actually take control of the process.
Yes, issuing official licenses to upcyclers or forming direct contractual partnerships with them. Imagine a system where a major fashion house has an official tier of certified independent upcyclers. The creators get to work with the materials legally and openly, and the brand maintains strict quality control and gets a cut of the profits or the positive PR securely.
I mean, I see the business logic there, but doesn't that completely kill the punk rock independent spirit of upcycling?
It definitely changes the tone.
Yeah, because the whole appeal of this movement was grassroots creativity, taking what the big corporations discarded and making it your own. If you have to apply for a corporate license to sew a patchwork bag in your bedroom, that's not really indie fashion anymore, is it? It just becomes another corporate subsidiary.
It definitely sanitizes the movement, but, it is a very common trajectory for creative industries. Think about music sampling in the early days of hip-hop.
Well, yeah.
It started as this incredibly raw, unauthorized punk rock art form. Artists were just taking pieces of old records and making something entirely new. Then, the massive copyright lawsuits hit in the 90s.
Right, completely changed the game.
Exactly. Today, you can still sample music, but it's a highly regulated corporate process where everything has to be legally cleared and royalties have to be paid. Upcycling in fashion is going through that exact same painful transition from the underground to the regulated mainstream.
That makes perfect sense.
Sustainability absolutely matters to society, but the courts are making it abundantly clear that the only safe legal path forward is collaboration, not unauthorized appropriation.
That music sampling analogy is perfect.
Huh.
It really puts the whole evolution into perspective.
Glad it helped.
To recap the journey we've been on today, what started as this incredibly noble pursuit of the circular economy, saving the planet one vintage jacket at a time, turns out to be an absolute legal minefield.
A huge one.
Yeah, whether you're cutting up a silk scarf in France, altering a luxury watch dial in Switzerland, or turning buttons into earrings in the US, you can land in major business-ending trouble, completely regardless of your eco-friendly intentions. The first sale rule is just not the bulletproof shield we all thought it was once those scissors come out.
It truly isn't. And as we wrap up our deep dive into these sources, I want to leave you with something broader to consider.
All right, what is it?
If the circular economy is universally agreed upon by scientists and society to be a necessary future for our planet's sustainability, but our current global intellectual property laws fundamentally restrict the altering and reselling of those physical goods,
Yeah.
are we eventually going to reach a breaking point? Are we going to have to choose as a society between protecting a brand's pristine legal image and legally protecting our environment?
Wow. That is a heavy but absolutely essential thought that the law hasn't quite caught up to the climate crisis yet. Definitely something for you to ponder next time you see a piece of beautifully reworked vintage fashion pop up on your feed.
Yeah.
Thank you so much for joining us as we unpacked all of this today.
It's been a fascinating exploration. Keep questioning, keep learning, and we will catch you on the next deep dive.